Former President Jacob Zuma says he's relieved to be a free man again. His 15-month prison term ends today. Zuma has thanked those who've supported him during this difficult period. He was sentenced in June last year after he ignored a court ruling to participate in the state capture inquiry. He handed himself in on July 7th, triggering the KZN riots that saw wide-scale looting and destruction. The former president was placed on medical parole in September 2021. But in December, the High Court set aside the decision and ordered him to return to jail. Zuma appealed the ruling and has been on parole pending the appeal's outcome.
We are able to confirm that indeed he complied with those conditions as he was being monitored by our Transport Committee Corrections Office, and they could check even on the system the visits that they needed to do when he needed to come to our office. Everything was done accordingly, so there was no penalty of any matter. Hence, then today we needed to ensure that we release him from our system.
Joining us to discuss the process is legal expert Elton Hart. Thanks so much, Alton, for your time this evening. So tell us first off, is it common for a judgment to be reserved, as this one has been, even after the term of the sentence has been served? And could that be problematic?
Annalie, if one looks at it, and this is now, it's a common practice that this can happen various times, and then it's like when we say the point that was argued becomes moot. And this is the instance now here where there was an appeal against the High Court decision that set aside the parole that was granted to the former president. And now we're still waiting out for the judgment or the outcome from the SCA. And although the SCA can now come and say, we confirm the High Court judgment, we upheld and we say that the High Court was right, it technically would become moot because we cannot send the president now back to jail because the 15-month period from when he was sentenced up until now has run out. So the period for his imprisonment, be it on any form of punishment as prescribed by the Criminal Procedure Act, has now lapsed. So we cannot send him back to prison. So even if they come and say the High Court was right in setting aside the parole that was granted to him, he has served his sentence. And that's the bottom line or the end of the story when it comes to the sentence that was handed down to him.
So before we get to what could happen, let's just find out what's caused the delay. Do you know?
No, the delay, there can be now many reasons why it was delayed and why it took so long, because the SCA is not just dealing with one case. There's a lot of appeals coming from across the country, and it's funneled to one court, which is the SCA in Bloemfontein, and they have to now listen to all these matters. And this one is actually, it was quick before the SCA because he was released in September. In December, the High Court made a judgment, and they actually then took it to the Supreme Court of Appeal. Some appeals take maybe 18 or 19 months to actually get to court, to actually being heard, because there's so many cases on the court roll, and that's now just the nature of the beast, because we only have one appeal court in Bloemfontein. Although we might have a lot of appeal judges, their rolls are clogged with a lot of cases, and that's normally where the delay comes, and that is now what we have to work with as legal practitioners.
So you're saying regardless of the decision of the SCA, former President Jacob Zuma won't go back to jail. So two questions in one. Will the SCA still deliver a judgment in this case? And if they do, what impact would a finding have where they would agree with the High Court saying that medical parole was granted illegally? Would there be an impact down the line for legal precedent?
Yes, indeed, because it will now create legal precedent to say that under certain circumstances, medical parole cannot be granted. And I think it's good that the SCA will give legal certainty and clarity on the issue on how the former president was granted parole, be it if it was right or it was not right. The SCA will now give us clarity on that issue as to when you deal with a person applying for medical parole, this is the procedure that should be followed. And this is where the Director General's authority stops, and this is subject to review by court. So for me, although his prison term has ended and he cannot be committed back to prison because he has served his sentence, because medical parole is still a form of punishment as set out in the Criminal Procedure Act. But it will now help us in future as legal practitioners in courts when we are confronted with a situation similar to this one. We will know exactly if a person applies for medical parole, this is the hoops that he or she has to jump through in order to qualify for medical parole. And that will then help us to actually now streamline and also improve, if one can say, if there's uncertainty in the legal system or in the interpretation of statute, because here it was an administrative process that was challenged, how they came to the conclusion that he qualifies for for medical parole. So I think the SCA will clear that up, and then we'll have certainty about that.
If the SCA does find that that medical parole was granted outside of the bounds of the legal prescripts, could there be any ramifications for Arthur Fraser, who signed off that medical parole?
Obviously, Arthur Fraser, that signed off, he's no longer the DG for correctional services. So from a disciplinary perspective, his employee, if he was still employed, they could have now taken him on saying that there was a dereliction of duty. But there is no criminal element or criminal offense that can be leveled against him, because he was just exercising his duties in the course and scope of his employment. So he's working under the auspices of his employer. So if somebody wants to do something, then you can say now there's the issue of vicarious liability. But what are you going to sue? Who suffered damages? Then it's now like, you need to show that I've suffered damages, hence I want some sort of relief, or I seek some sort of relief against the person who actually did an action or omitted to do an action. And this is now a classical example. This is a government official that allowed, and then if you seek, what type of damages are you going to ask the court to grant you? Because it's now, I think it was the Democratic Alliance that actually challenged and went to court and say, but this was incorrect. But then they will have to show that they have suffered damages for Mr. Zuma being released on medical parole, which I think will be very difficult. So one normally needs to look at, when a person goes for a certain type of relief that he seeks, or compensatory relief, that you can show that you've suffered damages. And in this case, it will be very difficult to show. If it was now Mr. Zuma, on the other hand, where the court said, okay, we revoke your parole and you are sent back, and the ACA come and say, High Court, you were wrong, you could have now claimed damages from the state for unwrongful detention. Something to that effect.
Yes. Let's talk briefly about the conditions of medical parole. And under South Africa's correctional law, prisoners eligible to be released for medical reasons include terminally ill inmates serving 24 months or less, those who are physically incapacitated, and inmates suffering from an illness that severely limits their daily activity or capacity to care for themselves. So in light of those facts, it seems rather contrary that former President Zuma has recently put up his hand to serve as ANC chairperson. Surely if a person is well enough to submit themselves of their own volition for active political duty, then that individual should be considered well enough to serve a jail sentence. Would that kind of information be considered when the SCA is making their determination?
Obviously, you must remember now, when we deal with an appeal, the appeal court is just is restricted to what is before the appeal court from the High Court. So we cannot now add additional information or evidence into the appeal record. They are bound by the appeal record. So although one can say that as a judge, you need to take cognizance of your surrounding environment and what happens in our daily lives, you still are confined to the record. So the state or whoever is bringing the, or who actually brought the initial application for the setting aside of the appeal decision, they cannot now come to court and say, listen, yeah, as early as, or just as recent as a month ago, this man actually said, I'm ready to stand for chairperson of the ANC. Surely this man is then not sick as he proclaimed to be in the papers. Because when the papers was drafted and submitted to court, that was the submission, and we did not know of this future event that he's going to raise his hand as chairperson. Although some might say we did expect it, but at that time it was not on the table, and hence that is where the court's hands is a little bit in shackles to just look at what was on the record in the High Court. So the issues that was on the papers when the application was brought in, the answering papers by the former president, that is what the court will look at and see, based on the papers that was before us, was the reasoning in line with the statute, and was the statute properly interpreted, and based on that, and also the oral submissions that was made in court. And then we have to sort of have stay within that parameters, and we cannot venture out of that parameters, because then it will mean now we're no longer looking at the appeal, but we're actually trying to now have some sort of further evidence being led, and that is not allowed in appeal situations.
Alton, do you think, as a legal expert, that the granting of medical parole, especially to high-profile political figures in South Africa, is problematic and needs to be reviewed?
I would really say that we need to review it, because I mean, if we look at as recent as Mr. Sheikh also got medical parole, and then at some stage he was seen on a golf course playing golf there. So I think there is some serious look into this process that is required as to how medical parole is granted, and also the people that is vested with the authority to make that decision. Because here we could see that the DG for the then Correctional Services, there was a report that says this man does not qualify, and then he obtained a further report that says, and you have two contrary reports, and then he said, okay, I'm going to use now my veto right, because I'm not bound by this decision. And so one needs to check and see that so much power not be vested in one person, because it might also just be that that person is maybe affiliated to this person who's seeking the relief, and then he grants the relief. And that is one of the nature of the beast that we have in South Africa. Because of party politics, people are employed or deployed to certain positions, and when they're in that positions, they have to now meet certain requirements. And for me, that is then putting some sort of a damper on the legal process, because now it looks like the courts is not functioning, the justice system is not functioning, because this person is getting away. And if it was an ordinary man on the street, he would have been treated totally different from what we see has happened here.
Thank you very much for your insights. That was legal expert Elton Hart giving us some comment into the fact that former President Jacob Zuma's prison sentence has ended today, while the SCA has not yet ruled on whether his medical parole was granted in a legal manner.